thank you, ladies and gentlemen, for inviting Elizabeth and me to come and talk with you today. This is not going to be a lecture. It's going to be interactive, as Susan said, and we'll go through the process on that in a couple of minutes. But we know that this topic of crisis in the C-suite is near and dear to all your hearts. You've dealt with many crises. And what we're going to do is deal with three scenarios, which will be presented not at once, but in a series. You will be put in breakout rooms after we discuss the scenario. Then you'll be in the breakout rooms. You'll select a chair. When you come out, the chair will be called on by Elizabeth or me to lay out the two strongest points that you came up with about how to handle the situation that we're going to ask you to deal with. There will be some questions which we can roll to the third slide that we're going to ask you to consider. Go ahead.
Yeah, no, I'm happy to do it. Thank you, Justice Lang, and thank you to everybody for being with us. So as Justice Lang said, this is going to be interactive. We're going to give you some hypos. And then when you go into your breakouts, you'll have about 8 minutes in that group to get organized, to talk through these general questions about what to do when presented with a hypo. And then we'll all come back together and hopefully have a really fulsome and interesting discussion about what happened in the breakout rooms and also some other things to think about. So in general, questions to think about for each of the hypos is, how should you react to it? How do you go about getting the facts? How do you tell your client what she needs? And the important thing there is what they need to know, not just what they'd like to hear. And then how do you provide advice, especially given that you're being confronted with a crisis with very little time to process and give your first blush reaction. And what do you do with all the other intangible things beyond the facts of the law, including the personalities that are present within your client group, timing considerations, and other things that would pop up into your mind?
Well, let's go to the first scenario, and Susan will lay this out for you. Elizabeth will lay this out.
That's okay, Justice Lang. Okay, so scenario number one, grand jury subpoena. So you get a call in your office from both the CFO and the CEO saying we've received a grand jury subpoena demanding production of documents and having someone appear to testify in a month. The subpoena is for all your accounting records for the past 5 years regarding your primary product pricing, attendance and expenditures at the quarterly meetings for the widget manufacturers of America, balance sheets, income statements, profit and loss statements, basically everything, including reports to the board and shareholders.
The next slide is probably the type of rapid fire questions you could get. Next slide, please. Okay, there we go. Question you'll get from the C-suite, from the big bosses. What is this all about? Do we have to comply? Is this at our own expense? Do we need to get outside counsel? And what legal problems does this raise for us? And by the way, drop everything and get to my office. So that's something kind of like we get from our clients as well. But what you get is from your main client, the C-suite. Now, when we go to the breakout, which we'll do in a second, you need to consider this. After you take a deep breath and comb your hair, what's your first move when you arrive in the CEO's office? What's your demeanor? What answers can you supply right away? And more importantly, what should you say and answer the questions right then and there and next steps? So if we're going to assign you randomly to breakout rooms, and please, someone, take the reins and be in charge, because when you come back, we're going to ask the leader or the spokesperson for a couple of the groups what the two major points were that you came up with. And then we'll discuss it as a group of the whole.
Welcome back. So as Justice Lang said, we're gonna pick on two groups at a time for each scenario. So I'm just gonna randomly say that groups 3 and 4, you're on deck for this one. And so let's start with the first question. Actually, you guys get to decide which questions you want to answer, and the two things that came through in your discussion. So let's start with group 3.
I think one of the questions that we sort of had a nuanced answer for was, do we have to comply? And the answer to this was on the list of questions that the CEO would fire at you, CFO would fire at you. To some degree, compliance may end up being required, but you're going to want to, and this answers a separate question, you're going to want to engage outside counsel almost immediately. That outside counsel will be able to speak with the subpoenaing authority and will negotiate and talk through what needs to be produced. You'll also do an analysis of what things can be subpoenaed, what things are within the subpoena power. That litigation component can't happen until shouldn't start happening until you've talked to your outside counsel with respect to the subpoena and with respect to the scope of the documents being requested. And so that sort of answers two questions simultaneously.
Let's touch on that for a second. Elizabeth, I know you have some thoughts about outside counsel.
Yeah. So first of all, I realize that outside counsel always tell you to call your outside counsel. And in this instance, I do think that's right. I think that for this, the issue with getting this kind of inquiry from the government is that you often don't know exactly what they're looking for, and we don't really have a good sense of what the scope might be. It could be as innocuous as wanting to ask and get some information about a competitor and some concerns they have about what that organization is doing. It could be because it's related to some sort of whistleblower key tam type of situation, in which case the inquiry from the government is just the tip of the iceberg. And so in this situation, it really is important to, one, reach out to outside counsel quickly, and two, for your internal client to get them ready to understand that it's very possible you're dealing with something that could get bigger faster, and that you need to start engaging the right folks to get your arms around what is actually going on. The other thing, just to flag, when you're getting the rapid fire questions from the CEO and CFO on this is, you need to get your documents frozen as quickly as you can. And even if you can't retain outside counsel immediately, you need to get that process going. And also start thinking about and talking about the fact that if it turns into a bigger deal, you may very well have employees, including high-ranking employees or officers or directors, who are also going to become the targets of investigations by the government. And in that situation, you need to be very cautious about who represents who, and making sure that those folks are provided an opportunity to get separate counsel if needed. That can get very expensive very quickly, depending on what kind of D&O insurance you have. And I think it's always better to front load that conversation with your internal clients, and say that you don't know the answer right now, but the questions you need to get answers on are these, and just prepare them that those answers could lead in a less expensive direction or a more expensive direction.
Just wondering if group 4 had any different take on that.
Not really. I mean, our first step was basically to read carefully, just take a breath, read it. Is it even, is it valid? B, are they even asking for anything you have? I didn't capture the list of what was in the hypo, but sometimes you get a subpoena for information you don't even have. It's not even related to you. So before you overreact, or we talked about just, don't just do something, stand there approach, read it, make sure you know what you're really responding to, and then get that litigation hold type of lockdown out. So very similar. We went into the outside counsel would be next.
I think it seems to me that's exactly the right approach, and it has to be with outside counsel as well. The approach to work with you and your clients to just say, I know you want this to go away, but we have to deal with this carefully so that we don't make any missteps. And I know that's probably what you hear all the time as corporate counsel. I want this to go away. Well, sometimes you can and sometimes you can't, but you can give them the comfort that you're working towards that goal. So I think that was good.
I had one other thought that I wanted to get your thoughts on too, which is sometimes in these scenarios, you may need to reach out to your normal outside counsel with the hopes that they will point you to someone else. And I just wanted to get your thoughts about one, what you think about that, and then also how you have that conversation with your outside counsel to ensure that you're getting to the right people.
I've heard general counsel say one of the best things that can serve them is when their regular counsel says, I'm not the one for this. You need X. And in a situation like this, if we got the call, I might just say, look, I know a lawyer who's been dealing with from the prosecutor side and the defense side for 40 years. He is known all over. And when you get that person calling up the U.S. Attorney's Office or the DA's office, they're going to listen because that person knows what he or she is doing, and they're going to have some respect. And so that coordination also is going to be necessary with you as well as your regular outside counsel because they understand your business, hopefully. And you can work with that former prosecutor and defense lawyer who is renowned and knows what's going on. So that's the way we would work it. Scenario 2, HR crisis. The VP of HR calls you on the phone, outlines the situation. For the last couple of months, an employee is repeatedly out of control, distracts others, and shows up late. Other employees have commented that this person appears to have changed, is really down in the dumps and preoccupied. She has always been very productive and innovative, a compatible worker here at XYZ Inc., and she has received 3 warnings, and the other employees are restless. So you get the call from the C-suite, from the HR director. And Elizabeth?
So the HR director and other employees are frustrated because it's been going on for a while. So the first question is, I want to fire her now, clean out her office, march her to the parking lot with an armed guard. Can we do that, and how? Second question is related to the recognition that her personality seems to have changed, that she may be depressed. Do we have to deal with that, or can we ignore it? And don't we need to do all of this today? So get in my office and tell me how to fix this right now.
And before we go to the breakout, once again, you comb your hair, take a deep breath. And, what's your first move when you arrive at the VP of HR's office? Again, what's your demeanor? What answers can you supply right away? Or more importantly, what should you say in answer to questions right then and there? And next steps. So those are pretty obvious points for you, we know, but keep them in mind. And now we're going to the breakout, where you will consider those very questions. The spotlight will be on groups 1 and 5. Let me take one first. Okay, what were the 2 points that you came up with, 2 major points?
Speaking on behalf of Group 1 here, we're all transactional attorneys, so all of us recognized our ignorance on HR matters or labor issues. But our 2 big points were to keep a calm demeanor, don't act rashly. So none of us recommended firing this person immediately before we do big point number 2, which is gathering more additional information, facts about, first, obviously consulting with either an internal expert, legal resource, or an external legal resource, and then getting all the facts together, in terms of, whether we followed all of our company procedures with respect to performance issues, and as well as any other kind of health or accommodation type issues. And then just, generally getting advice of counsel before you pull a hair trigger and fire somebody when, that could create some liability if we didn't do our due diligence first.
Yep. What about group 5? How did you come out?
Group 5 pretty much came out with the same questions. Obviously, with regard to demeanor, when is being calm and in control of bad demeanor? There are any number of problems that may or may not exist here. I mean, one of the things we wanted to know is there anything that's indicated that she's actually dangerous? I mean, erratic, there are a lot of erratic people that I've worked with over the years that were perfectly safe. So we'd want to assess the level of risk based on her behavior first. As we said before, and I think, mimicking what Group 1 said, we just need to know more facts before we can kind of make any judgment here which direction we're going to go.
That's right. One of the things that I've seen occur is, you need to know what the HR policies are. Typically, they're in writing, as you guys know. And one of the pitfalls that we've seen is that there may be great written policies, but only maybe the people in the HR office know what they are. And so those should be evaluated, immediately, so that you move according to those policies. And that's not going to surprise anybody, but it's something that is kind of frequently really not considered, regardless of how great the company is and how great the procedure is, because you need to follow those. The other thing that has occurred to me is it's not only whether this person could be dangerous to others, but danger to herself. If this has been going on for a while and there hasn't really been anything done, there's something in the process that you should be getting expert advice on. Somebody that could assist, who's a psychologist or physician that understands how to deal with this, so this person can be dealt with properly. You're not going to be able to cure him or her, but you can help them. And somebody pointed out to me the other day that when it comes to mental illness with employees, from a business standpoint, purely business standpoint, it makes more sense to help them stay in their job than it does to get rid of them, because of the obvious thing. You'd have to find somebody else to fit into her place. to do her job, train them, and you're behind the 8 ball. So it's clearly you have a humanitarian responsibility, but there's also, you know, that function of business that's there. Any other thoughts, Elizabeth? Anybody else?
If I could share one thought that I shared, I was in group 2 this time, shared this. It's not unusual for me to see our executives have different opinions and different goals. So we had information that the head of HR wants this person fired, but we also had information that this person's been a good and creative employee. And if that person's not actually working in the HR organization, I want to make sure and get feedback from the executive for whom she works. Because if somebody wants to keep her, that's going to be a whole different set of questions and advice.
Yeah.
All of what's already been said still goes into it in terms of helping her and making sure that she's not a safety risk to others. But I want to know what the company wants to do. And the head of HR, again, if it's not an HR specific employee, generally doesn't get to make that decision in the companies I've been in.
Gary, I think that's a great point. I also wondered if anyone talked about the fact that she's received 3 warnings and what those warnings might have looked like, who they came from. Is that signaling there might be some weakness in the policy itself beyond just dealing with this immediate emergent issue? Is that something that the company wants to look at a little more broadly, which I think falls right in line with the theme that you're raising, which is you all, or many of you, work for some very large companies that have sometimes conflicting interests within your client group. And so it's important to take all of that into account.
Absolutely. If you have any other thoughts, we'll, toss them out. If not, we'll go on to the third scenario. Third scenario, the deal blows up. We've all seen this. The executive VP COO calls you and says, our biggest competitor, ABC Inc., has hired 3 key engineers. The engineers all have our secret protocols and formulas in their heads. In fact, they help create those formulas. They also know well our customers since they're involved in the jobs and troubleshoot. Also, 2 of them have 1 year no competes and perpetual prohibition on sharing information. As of the third, we slipped up, didn't have them sign any contract of any kind like the other 2. Okay. Not infrequently seen problem. Elizabeth?
All right, so rapid fire questions. Can our competitor hire our people? What do we do to protect the trade secrets? What about their laptops? It seems like maybe they've been planning this for a while because some potential customers have now gone silent. What do we do about that? ABC is really aggressive. So should we just let them have these couple people? Also, the deal is supposed to close in 48 hours. So I need you to come to my office now.
Yep. Well, the next slide. Of course, as before, comb your hair, take a breath, figure out what you're going to do. What's your first move? What's your demeanor? Just as before, all these ingredients to showing up and trying to help out. What answers can you supply? What are the next steps? So we're going to break out. We have a few minutes left in order to do that. We'll be out for about 6 minutes. And group number 2 will be in the spotlight. As promised, room 2.
All right. So for group 2, the 2 big things, I think I think it's a given now to come in calmly with a calm demeanor and not act rashly or speculate. But the two big things we'd want to, make sure are done in this initial meeting is, given the urgency of matters like that, situations like this tend to you may actually do need to move quickly to discuss hiring outside counsel soon, in case I think it wasn't quite in the fact pattern, but someone had mentioned there might be a deal being done in 48 hours, so you may not have a lot of time. And the important thing of gathering all the information and facts with the documents, getting the non-competes together so they can be reviewed for scope and enforceability, any invention assignment agreements, any NDAs that might apply in addition to that. And then just getting other details about these folks and their work at the company. And if they have left already, I think there was a question about laptops and things to ensure that access to current company information and all that has properly been turned off, appropriately in accordance with the company policy. So those just be some of the immediate actions to take. I think kind of our big two there.
Anybody else want to add? I guess we could call on another room, but why don't you guys offer up if you have any other thoughts at this point?
Our group had come up, and I missed the very beginning of what was said here, so hopefully it wasn't already said, but our group had talked about sending a letter to ABC as well as to the individuals to put them on notice of the obligations that these employees have to us, so that if they continue and extract trade secrets, et cetera, that they're also going to be liable, not only under those things, but tortious interference and other things.
Yep. Those are important things that you've discussed. The issue on whether to commence a lawsuit is, as always, a very ticklish situation. And as though those of you who've handled these cases know, if they haven't done anything yet to steal customers or to appropriate, your intellectual property or customer list or anything of that type, if you can't tell that they've done anything, a lawsuit's going to be premature in all likelihood. I've seen these before where somebody in another company has fired off a lawsuit and they don't have any facts. And the trial courts are going to be pretty skeptical of the whole lawsuit if they're doing something prematurely. So there's a fine line between waiting too long and going too early. So you really got to know what's going on. The laptops, if you brought them back, as you know, you might get a forensic review of those to figure out if they have downloaded anything to a suspicious location in the recent period of time. You might consider, and this is a very ticklish deal, the potential customers who've gone radio silent, whether your marketing people can call them up and just kind of find out what's going on without tipping your hand on anything. What do you think, Elizabeth, about calling this competitor and just, giving them a shout?
I think Jeanette's team's idea of sending a letter to remind everybody is sort of a good middle ground between firing off the lawsuit too soon and potentially just doing it verbally. I think you could combine both. I think you could script a call, or you could call your counterpart within the legal department over there, do a call and then do a follow-up letter. I do think in general, once this thing starts to heat up, even if you aren't technically in litigation yet, as much as you can control your internal clients and have a single communication line that's going between, the appropriate person within the legal department at your organization and then your counterpart at the other, that's better. You you want to be controlling communications as much as you can while you figure out exactly how bad it is and how aggressive you need to be. So I like the idea of doing a call as long as you believe that that the right person can do it, and you won't have one-offs. And then I think it is important to follow up in writing. It doesn't have to be a threat. It could just be a polite reminder of exactly what the obligations are.
Yeah, nasty grams are not helpful, I think. You have to really kind of figure out the approach with the company. I'd also point out that, well, as you guys know, different states have different laws on this type of stuff. Texas is really looks hard at whether there's any indication of a violation. I will tell you that last year I was involved. We were helping a client that got sued in Ohio, and Ohio law is a little bit different. They have a theory that is called inevitable disclosure. Now, I've seen it in Texas too, but some people think when they go to Ohio, for instance, they can just, bring the lawsuit and get the injunction on the theory that it's inevitable that this engineer is going to spill the beans. I think that there's got to still be something in jurisdictions like that to show that they've made some moves over the line. But once again, that line is a fine one, and you guys will know how to handle that because you'll know the business and what's going on and what can happen. As you can see, we just wanted to give a little plug for the North Texas Food Bank. Our firm is now raising funds for North Texas Food Bank. You can join us on that link, or just help them out. As you know, they provide food to those who can't provide food for themselves. Thank you very much for participating. It's been really interesting and educational for me.